Hey everyone, thanks for joining us today for Startups in the Law. My name is Tret. I work here at Capital Factory. Just before we get started, I just want to let you guys know that um, throughout the day or throughout the event, Kyle's going to be taking questions from the YouTube chat. So feel free to type your questions and I'll fill them out and then I will let Kyle know. So without further ado, I'm going to bring Kyle to the stage and we're going to go ahead and get started.
Awesome. Thank you, Trev. Good morning, everyone, and welcome to, I believe it's the fourth edition of Startups and the Law. We do this webinar on the first Tuesday of every month for educational purposes. And we do this really because we want we want members of the startup community to really understand how to properly lay the legal foundation for their businesses. And also, just so that you can set yourself up for success in the future, as well as, um, I mean, lower that failure rate that a lot of people talk about when it comes to 9 out of 10 new businesses end up going under. To give you guys an idea, Jones Kertz, it's only two lawyers. It's only me and the other guy. Matt Jones practices law primarily in Oklahoma. He is one of the major startup attorneys that works out of Oklahoma City there. I am the Texas partner of the law firm. We go by two separate names, and we go by a different name in Texas. We go by Jones Kertz for law firm naming purposes. A little bit awkward, but we go by Verge Law Group in Oklahoma. So if you're attending this and you're in Oklahoma, that's the name we fly our flag under there. If you have any questions for us throughout, please take down our contact information. My email is kyle@joneskertz.com. You can give me a phone call, send me an email if you have any questions. Going forward throughout the presentation, we're going to talk about a lot of law, and in some cases, it's going to be pretty specific. If you have any questions, all we ask is that you keep the questions pretty generalized so that the rest of the people listening in can understand those questions from their perspective as well. And also, if I think the question is getting a little too specific, I may ask you to just send me an email so that I can answer it privately. That way, I'm not just giving straight up legal advice to the general group. So without further ado, we're going to go ahead and get started. Like I said, this is for educational purposes. Better education, better foundation equals more successful startups. We see a lot of that benefit with our own clients. It really does make a difference when you start out with a startup attorney, and in some cases, not just a startup attorney, but an accountant that works with startups on a regular basis to get set up financially there. And we believe that a lot of what we do really does improve the success rate of businesses. So you really can't go wrong with any sort of startup law firm if you're just getting started or if you're looking to grow your business. I highly recommend that you get one that's specialized and does your particular type of business, so that they can best serve you if you're looking for that sort of thing. To give you guys an idea, this is not a sales pitch. We're going to go through a lot of educational stuff. And so keep in mind that the first 30 minutes is going to be legal updates and news, and then we're going to move into COVID-19 contract language, which is there's been quite a lot of published material as well as stuff that's come across our desks that we have seen that includes COVID-19 language that goes specifically into contracts or other documents that we see on a regular basis. Then we're going to talk about board advisor agreements and basically go through what you need to know about those, including showing you some actual examples of what those look like so that you can better see what goes into those agreements and why those things go into those agreements. And then we'll move into executive employment agreements very briefly. But really the in-depth portion of this is going to be the COVID-19 contract language and the board advisor agreement FAQs. So without further ado, let's go through legal updates. VC deal flow has been a bit mixed, at least for us. Generally speaking, early stage deals have been down in terms of count, down in terms of investment size. I think that and based on the data, most of the investments that we're seeing are skewed much more toward very healthy revenue generating companies. In many cases, they're skewing toward profitable companies rather than non-profitable companies. And for the most part, a lot of people are refraining from investing in anything that has not yet made money. And that's part of the reason why the numbers here, if you look down here, the number of exits, or there's just more later stage financings than early stage financings right now. That's an expected pullback. We see that turning around whenever COVID-19 sort of goes away as a result of better medication and obviously the introduction of a vaccine that's viable in the market. And I mean, one interesting statistic that you can look up on Pitchbook, I believe they have an entire white paper over this from this link right here. The number of exits this year, as far as year to date goes, as well as what they're estimating for the rest of the year, is projected to be the lowest since 2011. Pretty significant. I mean, almost an entire decade away since we've had this low amount of exits, which means either those people are not able to get out because the companies lack the liquidity to purchase shares in the company to allow for an exit, or really those companies are just failing and they're not able to exit anyway. So there's some general business trends, and a lot of you will understand this. I mean, this is sort of telling you what you already know, but one key thing to remember when we're in the middle of a recession or a depression is that the number of new businesses is going to go down virtually to zero. It usually reaches record lows in times like this, mainly because most people are tightening up savings. They are hoarding as much cash as they possibly can and saving and being very, very frugal. And so they're not spending the money to go invest in new businesses. And a lot of people just really aren't investing in new products and services at the moment. A lot of people are also not buying products and services at the moment, which explains why very few new businesses are being started. So the common misconception really is that more people, as they become unemployed, are turning toward entrepreneurship. For some people, that is true. For the most part, it's really not. Most people really are just on unemployment at the moment, which is pretty unfortunate. And so, yeah, and I would say most white collar businesses are pretty much fully repositioning themselves as mobile or remote work businesses. To give you an idea, one of the largest employers in the city of Dallas, AT&T, is very much feeling the burden of the 4 buildings they have downtown right now that are completely unoccupied. And they are finding that they can do just about the same amount of work, if not more, just having people stay at home. And while it's not ideal and they have laid off quite a few people, the truth is they really are finding that it works. And I think for the most part, everybody else is finding that it works, though. The real downside is socialization. You obviously can't socialize the same way when you're working from home all the time. So other than that, massive adoption of mobile payment tech. I mean, nobody's doing cash anymore. Nobody's doing coins. As a matter of fact, if you heard that there was a coin shortage, it's because nobody is spending coin money and everybody is staying at home. It means nobody's breaking dollar bills into lower denominations, and nobody's exchanging coins at a cash register really anymore. And in some cases, that's just a matter of policy. You already know about massive adoption of teleconferencing, cloud, document management. The uptick in COVID-19 language, we're going to talk about that a little bit more, but this is something that came up when I was drafting something the other day, and I went ahead and did quite a lot of research on it to see if I could pull some good examples of what people are doing as far as what we would call innovating the law, which some people consider to be a vice, but the truth is we have to write something new into the documents every now and then. And then there's some new laws. I'm only going to talk about this for a minute. There's potential adoption of new laws allowing for better enforcement of business interruption insurance policies. At the beginning of the crisis, that was really important because a lot of people who had business interruption interruption policies, we're finding out that they didn't actually cover them. And the reason being was back when SARS happened years and years ago, most business interruption policies put a pandemic or an epidemic carve out into the documents. So the force majeure clause would have said something along the lines of, if there's a pandemic or epidemic, along the lines of SARS, along the lines of whatever other example, that's not going to apply. California has a new proposed law, and I think it was actually, I'm not entirely sure if it was enacted. I was just reading it this morning, but it aims to actually create what's known as a rebuttable presumption that your business interruption insurance is enforceable during COVID-19, meaning despite the fact that it had that language in there, really, if COVID-19 interrupted your business, they consider that the same as they consider that the same as physical damage being caused to your business. In which case, the aim there ultimately is to allow you to make a claim. So pretty interesting. California is usually on the progressive side, and they're used to changing their laws almost immediately. And I'm not sure anything like that will ever really happen in Texas, especially with the type of politics that we experience here. But you never know. If enough businesses are impacted, they might just force it on the insurance companies. Trent, do we have any questions? That's a really good question. The best way to do it is to interview them. You really do have to sit down with them for 30 minutes or so and talk to them. Most attorneys, I believe, will give you a free consultation. Some that believe they should make more money or make $1 every single minute of every hour will charge you a consultation fee. I don't really believe in that, mainly because you don't really get to build a relationship quite the same way with someone when you're charging them money just to listen to you in an initial phone call. I would say, if you Google startup lawyers in your area, startup attorneys, startup law firms, you'll find a fair share there that are billing themselves as doing technology. Doing technology startups. Doing other types of businesses and things like that, are helping entrepreneurs and investors. That's how we market ourselves as well. I would just say, keep in mind that not all lawyers are the same, and not all law firms are the same. A larger law firm is going to be able to move much more quickly than a much smaller law firm. That said, smaller law firms do move pretty quickly anyway. For instance, ours, we have plenty of processes set up to ensure that we can actually provide you the service that you would find elsewhere. So, other than that, though, do we have any other questions? Trent? Engage. Uber for legal services. That's an interesting question. There are some marketplaces, yes, but I'll tell you, I'm in a Facebook group with about 13,000 other lawyers in the state of Texas, and a large portion of them have had bad experiences with lawyer marketplaces. To give you an example, there are some pretty big names out there that are probably earning, hundreds of millions of dollars in ad revenue. But the problem is they're billing themselves as lead generators, and it really never comes to fruition. You really never get the benefit of the service you're paying for, and it does cost a lot. Also, a lot of people that sign up for it find that it's not just the money, it's just the quality of the leads is not there. You're getting a lot of people that only want free advice. They never want to pay anyone. And so it really is a tough thing to do, or a tough business to run. If it's something you wanted to talk about and you had an idea, I could discuss it with you and give you my thoughts on it. But it's lawyer marketplaces are a dime a dozen, and generally speaking, a lot of people don't see the value in them. I think we got one more question left, right? Yeah, so we set up new ventures all the time. Our practice does it all. I mean, we'll set up LLCs, corporations in Texas, Delaware, Oklahoma, other places where we are licensed and capable of doing so. Uh, we also help people with the growth side of things. So if you need venture capital investment, or if you're an investor looking to make an investment, we can assist you with deal documents, and as well as in some cases making introductions. The other thing I would say is, I mean, we do draft a fair bit of employment agreements. I mean, that just comes with the territory, and it actually is a significant portion of what I do. I'd say about 25% of all my work is spent drafting employment agreements of one kind or another for someone. But in other cases, we do specialize in drafting contracts that you probably really aren't going to find anywhere else. To give you an example, the other day I drafted a brand new agreement that you for learning pods, and that's a brand new thing that didn't exist until like a month or 2 months ago. So other than that, it looks like we have one more question before I move on. Is BI? I'm not entirely sure what the acronym is there. I'm based on operations. I'm not entirely sure what you're asking. If you would go ahead and clarify that in the comments, I could probably answer it for you. But I'm sorry, I just can't tell from the acronym.
Hey,
Going
Kyle.
forward, yeah, go ahead.
I think they were using BI as business insurance, or
Oh, okay.
yeah.
So yeah, most often business insurance is going to be tied to a physical location. Usually it's going to be governed by the same law as where you operate as your headquarters. I know a lot of people are operating virtually now, but generally speaking, they're going to want to use the state law of the place where you run your business for the most part. And that applies usually physically.
Oh, he clarified and said business interruption.
Business interruption insurance. So, yeah, I mean, like to give you an example, restaurants are often going to have business interruption insurance because if they had some sort of catastrophic event, I mean, their physical structure being impaired would really cause problems for them. But it usually is in the state where you're incorporated. It's usually not where the the insurer is incorporated. A lot of those agreements are pretty tightly drafted, though, and so what you're going to find is arbitration clauses that are really strong and favorable to the insurance company. That said, I mean, breach of an insurance contract is a pretty big deal, and I mean, there are a lot of lawyers that I know that do that litigate against insurance companies, and they win quite often because insurance companies just flat out tell people no, even though they have a duty to actually pay out the contract. I mean, that said, I think that answers your question. If it didn't, go ahead and send me an email, and I'll get with you a little bit later or after the show. Let's move on. Oh, hold on. So we've seen a slight uptick in pre-litigation and lawsuits among business owners. I just want to clarify, like, for residential property, tenants are, for the most part, really not paying. I believe the last statistic that I read was somewhere in the range of 40% of residential tenants did not pay. To give you an idea, that puts pretty big strain on the whole system, mainly because if you have leveraged commercial buildings, such as an apartment like the one I'm in right now, that are being run by property managers and owned by limited partnerships based in New York who have financing from some of the major banks or syndicate of banks. I mean, those banks are really feeling it. The investors are really feeling it. Everyone, like, they probably can't service the debt and are probably getting behind on it. That said, a lot of people have been renegotiating it, but the protections in the state of Texas, depending on where you live, have been lifted. And so in some places you're protected. I believe in Austin, many people were protected from eviction almost indefinitely, including in Austin for a period of time. I'm not sure if they extended this, but commercial tenants as well, they prevented evictions until just the end of last month by city order. But yeah, commercial tenants going bankrupt is also a huge problem. It means their creditors and landlords are intervening in bankruptcy proceedings to offset potential losses. And they're going to be doing that a lot more zealously because, well, they're not getting paid by really anyone at the moment. And so they're feeling pretty taxed, and a lot of those commercial landlords will probably go under as well. Some of their they probably got a whole host of entities that are operating, I mean, for the most part, but I mean, there's one that I know about in my dealing with somebody down in Austin that said that one of the major commercial landlords in the state of Texas, probably the largest one actually, was pretty much clearing the portfolio on bad leases, which means they were evicting people with impunity and just saying you're done. Pretty big deal actually. And then, I mean, investors of companies that are now insolvent are seeking counsel to get their money back and accuse management executives of misconduct. This happens a lot when you see companies go under. People are always trying to find somebody to blame when in reality it's just the market. I mean, in this case, I mean, you can't suck blood out of a stone. I mean, these companies are being bled dry by their vendors and creditors that they have to stay on with and pay. And so, I mean, their investors are going to be out their money, but there's really nothing you can do about that for the most part. Another big thing that I talked about last presentation, but I wanted to bring up again because we always have new people that are on the show every month. There's a Supreme Court decision saying that you cannot discriminate against people based on their sexual orientation because it is related to their gender. And while that, and there is one major exception to the rule. If you operate a religious organization such as a church, this rule does not apply to you because it was not tested and it was not fought in court all the way up to the Supreme Court. So major takeaways for this new Supreme Court case: don't discriminate against your employees or contractors for any reason related to their sex, gender identity, or sexual orientation. Even if you do run a religious organization or a ministry or something that is carved out of this rule, I highly recommend you don't do that. And the reason being is you don't want to have your last name slapped on one of the most pivotal lawsuits in the United States history, such as this one. I would really caution against that. You don't want the most important day of your life to be spent in court. Example of an employment staff policy in line with the Bostock ruling. This is something that was actually already in most of our employment agreements. As a general matter, we draft these pretty broadly in order to prevent any sort of judgments from overriding the terms. And even if somebody really asked for us to restrict it and say, hey, take out that sexual orientation thing before this ruling had happened, we probably would have said no because we have to advise against it. If you're discriminating against people, you're opening yourself up to a judgment. Or potential judgment and potential claimant. And so it's just not advisable. Some updates on Texas Workforce Commission guidelines. This is something that some people are probably already aware of, I'm sure, but I wanted to bring it up because some people aren't. These are FAQs that I pulled off the website, and so you can go look at these yourself. These are verbatim, but I pulled these questions because these are some of the most commonly asked questions that even lawyers don't know the answers to. So just so y'all are aware, if employee returns to work for full time, they're not allowed their UI benefits. They should stop requesting it. Failing to do so, failing to disclose is fraud. And at some point they will catch up with you because they'll see money flowing in and out of your bank accounts and figure it out. And so if any of your employees or you yourself are not doing that, you should stop right now, potentially go get a lawyer so they can talk to the Texas Workforce Commission on your behalf. That way you don't get in any trouble legally or criminally. And also, I mean, if you return to work part-time and your hours have been reduced, you may actually be eligible to receive benefits. Keep in mind that the additional $600 that was being applied to unemployment benefits is no longer being applied for the most part. I believe that there's another act about to go through. They're estimating at least another week on that. And it appears it's going to be similar in size to the last one, though I'm not sure. I'm not sure it's really going to ever get there. I think our politicians are really holding their breath for a miracle at this point to prevent them from having to distribute more money. Anyways, when it comes to UI benefits, each case is evaluated on an individual basis. There's no blanket. I mean, it really is a matter of how you have been affected personally by unemployment. And so there has been clarifying guidance, though, for people who are concerned about going back to work in a place where they could potentially be exposed. And here are the guidelines. Reason for refusal. I actually want to call these rights to refuse, mainly because they have basically given you a list of, 6 items that you can cite as basically your right to refuse to go back to work, as well as your right to claim unemployment benefits if you fall under one of these categories. So if you're of an older class, which is a more vulnerable class of people, or you have pre-existing medical issues that could really be compromised by being sick with COVID, you have an excuse. If you're a household member at high risk, you have an excuse. If you're diagnosed with COVID, obviously you have an excuse. You shouldn't be going to work, or at least you should be working at home if you're capable. Family member with COVID, if you're taking care of somebody else, they understand that. Quarantine, I mean, you get that 14-day period paid for by unemployment benefits, so you might as well go claim that. That said, that fifth one, I don't really recommend that you use that often. There are probably quite a few people who have attempted to use this like every week or every 2 weeks and say that they're re-exposed on the 15th day and then they go back under quarantine. Don't do that. I mean, they're going to accuse you of fraud, most likely. Childcare, obviously, if you got to take care of your kids and you can't be away, and there's no reasonable alternatives because you can't afford them, you've got an excuse. So this is an interesting question that is on the website as well. Are employees on paid medical leave considered unemployed? The answer is no. Why? Because they're on paid medical leave. Employees who are told to stay home for such reasons because they are afraid to go to work would be able to use available paid medical leave under whatever paid leave policy the company has. Employees who are refusing to come to work because they are afraid should be treated the same as those who cannot come to work because of a medical condition. That's really what the website for the TWC says. I had to paraphrase them a little bit because it was inartfully worded, but I feel like I got the intent correct on this. While on paid medical leave, these people would not be considered unemployed under TWC laws, not able to claim unemployment insurance benefits. So, and then I want to go through a word on COVID-related bankruptcy. Bankruptcies are happening they're just skyrocketing at the moment. I have a friend that works at a bankruptcy law firm out in Fort Worth. And I mean, their business, they just hired a few more people just to handle the workload. The reality is a lot of businesses are going bankrupt. In some cases, it's just totally unavoidable. To give you an example, if you were in a co-working business, something that used a lot of real estate that really is no longer accessible or usable in the capacity that it was before, or the density that it was before. And this applies to restaurants, this applies to other businesses that use a lot of real estate. I mean, you're probably feeling the heat right now. And so I would say a lot of those people are actually filing bankruptcy. Some of them it's just restructuring. If you do have assets that are marketable or you have cash on hand, but your debts are just getting way, way too high, or you're way too in arrears, restructuring might be a good idea. But if you are hopelessly behind most bankruptcy lawyers are going to recommend that you liquidate, which is basically you liquidate all of the assets, then you terminate the existence of the business. And I mean, it's not a fun process, obviously, either way. But the truth is, sometimes you need to just bite the bullet and do this. And really, if you are there, I highly recommend you find a bankruptcy attorney to help you. There are plenty of good ones out there. You honestly don't even need a recommendation from another lawyer unless you want one to find a good one. So that said, I'm assuming that most people are not here for bankruptcy advice because they're here for startups. Anyways, like when you're thinking about that though, take into account the amount of cash you have left, whether you can generate additional revenue, whether you're profitable. Most people are probably not profitable at the moment if you're considering bankruptcy. Whether you can increase sales in the short term, a lot of people are really struggling with that. And then other forms of financing like that you can exit, or injections of outside capital. Some people will go back to the venture capital investors that they previously got money from. The only problem with that is most people are pretty tight right now on the wallet. They're probably not going to invest any more money in you or give you a bridge loan because it's just too risky. And then so the other thing to consider is just potential sale of the company and its assets. You can find a business broker if you have good enough and marketable enough assets. The reality though is the business has to survive long enough to be sold. It also has to survive long enough to last until after COVID, or at least long enough for you to actually get through all the closings related to selling a business. Other than that, though, let's go into COVID-19 language. Trey, do we have any questions, by the way, on that last part? Nah, doesn't look like it. So we're moving on. So here's an example of modifications to an employment agreement and agreements for compensation that you can make. So just to give you an idea, this is basically an amendment to a executive employment agreement or a regular employment agreement, where this is saying the employee and the employer are agreeing to an amendment where they're reducing the salary of the individual based on events that have happened. And you see the language right here in the middle paragraph, taking due to the novel coronavirus pandemic. I mean, this is brand new stuff. This has not been really seen before, and it's interesting. The truth is, though, I'll tell you, I think it would be smart to incorporate something like this into a general practice, where instead of calling it the novel coronavirus pandemic, this is your plan B for all of your employment agreements for whenever there is another pandemic, because based on what health professionals are saying, at any point in time, we could be in the same situation. Like people will say this is a once in 100 year, like a virus or disease. The reality is, I mean, it might not be another 100 years. It might not even be 20 or 10 before we experience something similar. So worthy of consideration, adding into the portfolio of contracts that you have on hand, if you want them. It would require a little bit of negotiation in some cases. I probably, for this one, would not allow this to be an agreed upon sort of thing. I would probably put it into the original employment agreement that this is a unilateral right of the company where they get to unilaterally reduce all employees that are of similar kind down to a certain threshold of income. Like, just that's what you get, nothing else. You don't get to agree on it or anything like that. And if you disagree with it, well, you can resign, or we can disagree and you can be fired for it. Because the reality is, if you don't have money, you don't have money, and you can't pay people, you have to let them go. This is one that I've seen different iterations of this all over. I saw one in a publicly traded company acquisition the other day that was enormous. But the general gist of it is the force majeure clause, like, is carving out pandemics and epidemics, and then using language related to the coronavirus, sort of dancing around it and saying, like, by way of example, similar types of viruses. Also, it can't be anything that was in existence at the time. So, like, for instance, if this were an agreement you were agreeing to, I pulled this out of a limited partnership agreement, by the way. If this were in an agreement you're agreeing to and you saw this, I mean, the truth is, I think you should agree to it. Most people are going to want it, especially if the stakes are high and the amount of money is there. So, that said, I don't think this is the best written one. I would not use this, at least the red language. I mean, I would probably doctor that a little more before it goes out for signature. But anyways, this is a good example of one where they're carving out the pandemic or epidemic exception and going a little further with the language and pointing out that this is about COVID-19. The corporate annual meeting notices. This is an interesting one. This one, if you read this, if you go down to this portion right here where it says and file them with the SEC, that is really for publicly traded companies. But I mean, for startups, you could actually use this clause if you're communicating via email to your investors or your shareholders and saying, hey, we can't hold this meeting. We can't do this right now. And so all you have to do is just lop off that last part at the end and file them with the SEC and change this for your purposes, and it might actually work. And I don't think that's really bad at all. And it's actually a very smart thing to have on hand. Recommend that everybody have this like in a Word document or something like that. Other than that, sample risk factor stuff. So just so y'all are aware, in annual and quarterly filings for publicly traded companies, they usually have to list risk factors for the company, very similar to the way we list risk factors for potential investments in venture capital funds or potential investments in, or larger investments, I should say, in privately held companies. And so this is basically saying we have third-party suppliers who are in China. The outbreak has really taxed us. It's going to be a while before we recover. Yada, yada, yada. The reality is this is going to be standard fare for everyone. People were joking the other day that it's the standard of disclosure as far as financials go for publicly traded companies is no longer EBITDA, it's EBITDA-C, meaning you have to disclose your financials plus whatever the effect of COVID, whatever the effect COVID has on your business. And I want to touch on that a little more because from a privately held company standpoint, let's say you're raising money. Let's say you're raising $500,000 right now or something like that. It probably is a good idea in your documents or your subscription agreements, whatever documents you have that those people are signing, that there is actually some sort of risk factor language where those people acknowledge that there's pretty high risk to investing in a company in the middle of a crisis like this, because we have no idea how long it's going to last, and we have no idea what the negative impact will be, and whether or not the company can sustain itself even with an investment. And so, I really actually like this stuff. This is additional risk factor language. This is more for people that I think more appropriate if you're raising money. The previous one is obviously more appropriate if you're a publicly traded company, which obviously I don't think very many people here are. But good stuff to have on hand. I mean, describes the extent of the impact. I mean, and then you're basically going to insert your products and services description so that people understand, well, overall demand has declined for XYZ, which is exactly what we do. You can make this industry specific. You can make this sector specific. Doesn't really matter. I mean, I would say you want to keep it broad. I mean, going way too specific though, not really advisable. You don't want to be too specific on this because you don't want people to be able to poke holes through that risk factor and say, you didn't tell me that this particular part of the risk was a risk, like of the risk factor was a real risk. I mean, you just said this stuff. So keep it general is what I would say. All right. Do we have a question or anything like that for that last section? All right, guys. Moving on to board advisor agreements. I did get a preliminary question about this and wanted to address it in depth. I've done about 6 of these in the last 2 weeks, which I mean isn't abnormal, but it's a I mean it's getting up there. I thought we were going to get to 10 or something like that within a month, but so board advisors are commonly called advisory boards. Some companies, especially larger ones, are going to have full-blown advisory boards, which may have something like 5 to upwards of 12 people. 12 would be a lot. It's also, I mean, it's kind of a misnomer calling these advisory boards, because for the most part, for early stage startups, we are not creating advisory boards. We are just hiring advisors to the board of directors and to the company's executives to help them with decision making and help them and help cover the ground that they can't cover based on their own core competencies. So the idea here is you're fulfilling some sort of skill set or relying on somebody with a type of expertise that no one else in the company really has, or what you're really going after is experience. You're looking for somebody who's been around the block, not just once, but a few times, to tell you how things go. And I mean, these people can help you with fundraising. These people can help you with growth. They can help you with development of software, with conversations that you need to have with your employees. They can advise you of every aspect of your business. It doesn't just have to be a very specific one. It can be very general in nature too. So in general, the type of contract you need is a board advisor agreement. And I mean, that literally is what it's called. So when should you have one? Really no clear answer, but I mean, my recommendation is when you feel like you are not able to run the business without somebody else's advice and you just need instant access to that person to ask them a question to help you make that decision. You're not always, CEOs and CFOs and CIOs are not always making decisions by committee. Oftentimes they're just relying on their best judgment and their gut feeling. But the truth is, it is always nice sometimes to call somebody who knows the answer. And that's really what an advisor is there for. I mean, in some cases, it will be very indirect advice. In some cases, they will tell you, no, this is exactly what you should do. And so depends on who you get. But I would say it's like when you should have one is really business life cycle agnostic. You can have them whenever you want. You can have them from the outset. You can have them 6 months after you start. You can have them a year after you start, or 10 years. It doesn't really matter. I mean, there are advisory boards for publicly traded companies, advisory boards for all different types of businesses. So, and why have any advisors? Like I said, you're supplementing skill sets, know-how, experience, etc. So the scope here is really important to understand. I think some people they don't really understand this aspect of it so much, and this is getting down into what the terms of the contract really do say. Typically, an advisor is not going to have a vote on anything. You'll rely on their advice, but those people will not. They're allowed to sit in on board meetings and do so in a board observer capacity, but they do have the ability to offer input and discuss things with the company at length and the board of directors. But the truth is, they do not get to render a vote. They don't get to raise their hand. They don't get to say yes or no. It's input, and then take it for what that's worth. Different ways to be compensated. You can be paid in equity. You can be paid in cash. It can be a mixture of both. We'll talk about a little more about that in depth and where to really draw the line on either of those things here in the next slide or two. Other duties, though, I mean, like I said, general advice are going to be very specific to your skill set. They generally have no ability to control the company's path or direction. They're not steering your company for you, nor do they really want to. They're in an advisory capacity only. And you need to make sure it stays that way. That person is not there to open up the office for you. Like, that person is there to answer a phone call and let you ask a question. Regular meetings. So usually the terms include something along the lines of a monthly meeting or a quarterly meeting or a semi-annual meeting. And in some cases, those will be in person, depending on whether or not you're in the middle of a super deadly coronavirus pandemic or not. But yeah, I mean, they like, you need to figure out how frequent is enough. It really is a judgment call on you and what you want. I mean, I can't sit there and tell you what is the best decision to make when it comes to quarterly or semi-annual. I mean, at a minimum, it should probably be semi-annual because you don't want those people to forget about you. But I mean, I would say it would be really irregular if it was just once a year you have advisors hanging out with you or giving you any advice at all. Uh, they usually do go to annual meetings or attend them virtually. And those annual meetings can last from 4 to 8 hours. And so if you're doing one of those things, obviously you need to have an agenda set up. You need to be very organized and you need to keep those people's attention. In some cases, you do need to make sure that they're going to have breaks throughout the day to do what they need to do and make sure that they know well in advance what you're doing for 8 hours. Because otherwise, they're not going to really want to stick around, which is a problem for advisors. I'll get to that in a minute. The periodic phone calls, meetings is needed and prescribed by the agreement. Usually there's a term that says this person will be available for phone calls once, twice a month for 1 to 2 hours, something along the lines of that. It usually is that specific too. And you do have to think pretty hard about how much time is enough. Keep in mind, most people on a weekly basis are probably working somewhere in between 60 to 80 hours a week. I would say if they're doing any sort of advisory services, they're probably very busy individuals. And so 1 to 2 hours worth of their time can be a lot if it's on a weekly basis. Usually we would limit it either to a biweekly or a monthly because it's not essential that you talk to those people every single day unless you absolutely need their advice and they're providing enormous value to you. If you are talking to them every day, by the way, you might as well just hire them as an employee if they want that. And here are some examples of what these clauses look like. I want to give you a chance to actually read through this stuff because, I mean, this does pretty plainly explain the duties of these individuals. This is one that we actually drafted for one of our clients, or at least this was the skeleton that I used before I tweaked it specifically to their business. You can see where I was talking about participate in monthly advisory calls with members, at least one that lasts at least 1 hour, no more than 2 hours, most likely. And you do need to be just keep in mind, be mindful of people's time. You may be paying them in equity or you may be paying them in cash or both. But at the same time, you don't get to monopolize their lives over your business. You want to make sure that these people are kept happy and that they are willing to come back and help you. So, yeah, and at the bottom here, you see participate in an annual full day retreat. Sometimes, I mean, that can be expensive. If you're doing that, most people are going to want you to pay all of their travel expenses. So, just be mindful of that. If you start demanding their presence in person, pretty definitively. Hey, Trent, it looks like we have a couple questions. So, a director of a company is going to be pretty much named. So, to give you an idea, like if you're a CEO, if you're a CFO, you're a director of a company, unless you have something in the bylaws that says otherwise. That would be very strange if you did. But yeah, the major difference though is an advisor is not a director. They do not have capacity to alter the course of the business. They do not have capacity to sign on behalf of the business. Usually they do not have capacity to do anything other than answer a phone call from one of the directors or officers. They have no authority to bind the company to any contracts or anything whatsoever, whereas a director usually will to some extent. I mean, for instance, in most bylaws will limit the ability for certain individuals to sign, even if those people are in the C-suite. But yeah, I mean, usually we give the CEO power of veto over all those actions, if unless there's some reason we need to give everybody else or other individuals specifically the ability to sign contracts, to take out loans, to do certain things. Other than that, I think we have one more question. Yeah, you're absolutely right. It's pretty similar. The only difference, though, is you should think of a consulting agreement as more as providing, in some cases, more value. So when I think of a consulting agreement, I think of a person who has extreme professional expertise. They do this for their career. This isn't a hobby. It's not a retirement gig. Whereas being an advisor on a company can be. It's sort of a it's sort of a side gig for some people. I do know some people do advisory services for a living, doing this sort of thing. But generally speaking, like, I'm providing my time because I have a relationship with the founders of the business, or these people have asked me because I know how to do this stuff or did it before. Yeah, we'll give a copy of the slides out afterward. I believe there's one more question. Where do startups find their first advisors? You have to network quite a lot, in my opinion. In some cases, your first advisor could be somebody that is directly or indirectly related to one of your investors. They might say, your investor might say, hey, like, we're putting a little bit of money into this thing. I'd like this guy or this gal to oversee and advise a little bit for you. I mean, maybe have a board observer, right? Maybe be in an advisory role. And so, I mean, the truth is, like, finding them is really up to you. You can network a whole lot, and there are people that, I mean, like I said, they do this for a living. Like, I would be so cautious, though, about the people that do this for a living, because those people are sophisticated and they are known to shark people out of equity in their company. And it's one of those things that I was going to talk about here in a little bit. So as far as the term goes for these sorts of things, minimum is going to be a year. You need it to be a year. Any shorter, I'm not sure you're getting the value out of it. You need to build a relationship with this person and work with them on a regular basis. That said, you don't want it to be forever. It doesn't need to last probably longer than I would say the usefulness of the person. Because, I mean, you get down the road 2-3 years, at some point you will outgrow your initial advisors, and it will make sense for you to probably have additional ones, or just drop the previous ones and not renew their contracts. And so, and in some cases, you may have given up equity in exchange for their advisory services, and so that can be a bit not as fun of a conversation to have with people. That, hey, I know you have a stake in this company, but we're no longer taking your advice, like, on this basis. We're going to go with this guy and do the same exact thing. It's that can be a hard conversation to have. So just keep in mind that there is, at some point, you do have to exit these contracts. It's an important thing to keep in perspective. So compensation, this is really where most people are just most nervous about this. So I did 3 agreements the other day that were only cash. And those, in my opinion, are preferable to the situations where we're offering equity to those people. Advisors can be somewhat notorious for showing up and then attending maybe one meeting that they were obligated to, and then you never hear from them ever again. Those people never answer their phone. They never return an email. And so you are sitting there holding a contract that has no clawback term, no recapture term for the vested equity provisions in that agreement. And that is a serious concern. You really do need these contracts, if you are giving away equity, to have a clawback provision and an ability for you to get your equity back, whether that means you're repurchasing it from them or you are actually, or you're just, or they suffer what's known as forfeiture if they don't perform. My preference is forfeiture, because forfeiture is fairly extreme. We're just going to notify you that you didn't get it, and it's because you didn't show up, and it can be for any failure. In some cases, we put a materiality qualifier on things where there's a material failure to perform the obligations under this agreement. The reality is, like, in some cases, these people are meeting so infrequently with you that it makes no sense to put a materiality qualifier on that, because, well, if they miss one meeting, like that's potentially 8 hours that you didn't get from them that would have been really valuable if you did. So I would say for compensation, I would lean heavily toward cash compensation if you're doing this. If the person is going to provide pretty extreme value, or they want equity and you have the ability to give it to them, I would say consider it, but make sure you obtain counsel, make sure it's the right fit. You don't want to be giving equity to somebody that isn't going to stick around for very long, and not support your business the way you want them to. And so here are some actual like stock option / equity compensation terms. If you're looking at Part C, non-qualified stock options, those are the most common types of stock options, by the way, for startups. And then below that, I believe, let's see. So stock appreciation right. So most people don't understand what stock appreciation right. It's actually really simple. You're basically acknowledging the value of the stock, but instead of giving them stock, you're just giving them the equivalent in cash. So they don't actually have, like, their upside is cash basis and will be paid out to them eventually, but it's not going to be, hey, you're getting stock certificates, you're getting put on the cap table. It's a cash equivalent only. Some people ask for that. That's not that bad of an idea, in my opinion. But if you're looking at this language right here, where it says Black-Scholes option pricing model, we don't put that in venture. We usually don't put that in early stage venture contracts. The reason being is that is a publicly traded company finance concept. To give you, some of you might be mathematicians or engineers or scientists. The Black-Scholes option pricing model is derived from physics calculus, and it's actually the root of it is really based in risk assessment in physics. And consider like the scenarios where like rocket scientists are weighing the risk that a rocket will blow up in midair or something like that. I mean, I'm not sure I'm hitting the concept quite on the head, but like from what I understand, that's basically what the Black-Scholes option pricing model is derived from. We don't include that though, because it's far too complex. And also it's just not a concept that we rely on very much. It's much easier for us to just rely on fair market value, or the value based on some other criteria where we can measure it in a cap table or something like that on a price per share basis. We don't really want to be throwing in too many difficult equations on this to get from A to B. In some cases, you have both option shares and stock appreciation right shares. I probably wouldn't recommend including subpart E. It just overcomplicates it. I would say do one or the other, not both. And yeah, I mean, you can do cash and equity compensation, not a big deal, so long as you can afford it. And the only thing I would keep in mind though is equity is pretty expensive. And what I mean by that is the upside on equity, if you have a successful company, it could cost you in the millions. Whereas if you just paid that person in cash to get you to where you wanted to be, like, you could have kept more of your company for yourself. So, I mean, when you think of equity, don't think of it as I have this marketable asset. Think of it as I'm literally giving away something that would make me wealthier if I didn't. Like, And I think when you frame it like that, it's a little easier to understand how much value a company's shares or a company's membership interest has. Expenses, this is a pretty typical one. I usually try to make it so that we're not reimbursing anyone for expenses. If they ask to be because they're traveling into town or out of town on a regular basis, or they're doing other services for you where you're regularly meeting up with them and having them drive to places, well, yeah, maybe cover their expenses. You can cap it though at a reasonable amount. I recommend you do that if you're going to do that. That way people don't get carried away. To give you an idea, I mean, the way they could get carried away, if people were traveling by car, they could charge you 57.5 cents per mile. And so that adds up a lot. I mean, I used to drive for a living back when I was in college, like for a bank, and I was going back and forth to the different branches, and I was getting the pay was really nice, despite the fact that, I mean, the trips weren't really that long. So other than that, like here are a couple questions I like to throw out here. It's basically here are common examples that we get from our clients. An advisor wants me to give up equity in exchange for advisor services. What terms do I need to protect the company? I mean, like I said, equity is expensive. I mean, more often than not, better to pay equity to an employee, executive, or sell it to an investor rather than give it to advisors who don't really answer your phone calls. Make sure you get a favorable clawback and recapture provision. Even better, get a forfeiture provision in there rather than repurchase terms, so that you don't have to pay them fair market value of vested stock options. Other than that, definitive performance obligations. If you think they're gonna try to be slick and get out of this thing with your equity, I mean, put in more definitive performance obligations. Make those hours really count, and tell them what they got to do to earn it. It really is the best way to get them to perform, and it really is also the best way to prove if they breached those obligations. A way to measure that performance has been rendered. You want a standard, and you don't want it to be something like reasonably perform. It needs to be pretty definitive. Like, I mean, you and that person need to put it in writing that this person actually did it. Both sign it, and I mean, it's kind of like having like that sounds like something you did in grade school, but the truth is, acknowledging something that happened in writing is, when it comes to protesting that in court or something like that, or arguing about that when a lawyer like me is going back and forth with their counsel over whether or not this person actually owns the shares that you gave them in terms of vested options. Well, I mean, if I have something in writing or I don't have something in writing and you were supposed to, proof one way or the other, that really works. An advisor who is available and accessible, like I said, this person needs to be able to answer your phone calls. They don't need to answer on the first try, and you do not need to be calling them at unreasonable times. That said, they need to be available during business hours, or, I mean, at a set time, like on a set day for you to be able to call them, so that they understand when their office hours technically are. I mean, most advisors don't want to be tied down like that, but if their schedule is so busy, it makes sense just to calendar everything out in advance and say, I'm going to talk to you on these days at these times. It will help you ensure that they perform their obligations and that you get the value out of this contract. Another question: our company gave a previous advisor equity, but they never advised or did anything. Can we recapture our equity? We oftentimes see this with people that signed advisor agreements without seeking counsel first. They didn't have anyone on their side negotiating it. Even if they did have a lawyer, they just signed it because they trusted the person, because that person was pretty smooth. You don't really want to be in a situation where you haven't had a lawyer at least look at it first. Like, and I hate to say that because it's like, you always need to come to us and pay us. No, that's not the case. The problem is, like, you're potentially what if 1% was worth $1 million? Your company is valued at 100 million at that point. But you're sitting there giving away a ton. If you're not having somebody at least review it and advocate for your interests. And by the way, if an advisor is giving you an agreement, that's a sign that they probably had a lawyer draft it, and that's probably pretty favorable to them, and that you should definitely look at it a little more closely. I would never really recommend that you sign one without at least having a lawyer lay eyes on it first and tell you what it says really. So the big question is, like, if you're in that situation, there are a few questions we walk through. Is there an explicit clawback or recapture provision? If the advisor drafted it, there's most likely never going to be one of those. If there is, I don't know why they put it in there, because it doesn't serve them very well if they intend never to really perform and just obtain equity in your company. The next question, if not, was the advisor required to perform rather than just make themselves accessible or available to the company? So that's the difference between you enforcing that performance by saying we are meeting at these times on these specific days, or else, unless you schedule it otherwise. If you just leave it up to you or the rest of the board members to get in contact with that person and use up a set bank of hours, that can be difficult to track. I mean, you really do have to be diligent when you're tracking that sort of thing to ensure performance as well. But the problem is, if it's just one of those things where if you don't use it, then they still get their equity. I don't really know if that's such a good idea, but I mean, it all really depends on what you negotiate too. So the other question, if not, did the advisor breach any other provision of the advisor agreement? More often than not, most of the other provisions are not going to be dispositive or going to control the outcome of whether this contract is truly enforceable or not. So it really does matter, like, did they perform? Did you pay them as well? Because, I mean, it's possible that you might not perform, at which point they don't want to provide any services to you if you're not paying them. And by the way, if you're giving them equity and it's vesting over a period of time, at some point you do actually have to acknowledge the vesting of that equity. And in some ways we do that by resolution. There's some software services, you might have heard of Carta before, that will help with vesting of incentive stock options, non-qualified stock options, or other stock. And so there is a way to notify people that the vesting of a particular set of shares valued at XYZ has actually occurred, and that this person has been issued those shares. So if no other options, does your company have the money to purchase the advisor's equity? That's a last resort, obviously. The other questions are designed to try to get you out of having to pay that person to repurchase their shares. So, and you may end up paying premium for that. I would recommend, though, that if there is any sort of repurchase term in there, that it has to be valued at the fair market value of the shares at the time, or something like that. Or if you're repurchasing it because that person didn't perform, that you get to repurchase it at a discount. I don't believe you're allowed, in some cases, to really. I mean, you can purchase at a discount. I mean, I would just say, like, keep in mind that, like, fair market values are somewhat intangible of privately held companies. I had to coach one of our clients on this the other day. We're talking about a company that, for the most part, I mean, like, I understand how founders will value a company right before they're about to raise money or something like that. The truth is, though, if a company has no working prototype, has no customers, has no products or services otherwise, and all they really have is pretty shiny IP, I mean, that has no other tangible value and isn't really tied to any products or services. In my opinion, the fair market value is either zero or really dang close to zero. The reason being is you can't claim that you compete with anyone if you don't have customers. You can't claim that your product has any value, like, if you don't have customers yet. And so if I'm arguing against the other side that, hey, we didn't pay you anything because we value the fair market value of the company at nothing, I mean, the reason we did that had to do with the fact that you are, I mean, for the most part, well, I mean, the company's worth nothing. I mean, I don't have to purchase anything; it's worth nothing. So, or repurchase it at zero. That's a bit. I would also say, like, don't ever really go that tack. I mean, like, you are much better off if you just pay somebody, like, rather than, yeah. Go ahead. It looks like we got one more question. Um, so, I mean, if, like, we usually use hours because it's a quantitative measure. If it's a qualitative measure, it, it gets hard to acknowledge when the performance has actually taken place. Like the like it. I mean, if I mean a qualitative measure. I mean, it really is hard to come up with an example, but at the same time, like, I would say, I mean, it could be that you're satisfied with the contract and you acknowledge that they fulfilled their duty. There could be a term in it like that. That's really using my imagination on that. We usually don't make it that. I guess. I mean, we usually don't make it that open because you're. It's just leaving too much to interpretation unless you have something acknowledging that the contract has been completely fulfilled and that person is released of any other obligation to do such a thing. So, um, yeah, I mean, I would say, I mean, it really is just better to measure everything on an hourly basis. And to the point of, like, is time a good measure? The truth is, the person who gives bad advice is in some ways valuable to the company in similar way to those people who give really good advice, because we can very clearly, when we're putting those two people up against each other, who is wrong and who is right. And so there is value in having somebody who, in some cases, you're not attributing much value to their presence or their input, but I mean, they're helping you figure it out anyway. So, uh, if we don't have any more questions, I'm going to move on to the summary of executive employment agreements. These are for C-level executives as well as vice presidents, things like that. I mean, that you might bring on. Usually for early stage companies, we're usually doing the C-suite. We're normally never doing a vice president capacity unless the corporate structure demands it. And so, I mean, most common early on is going to be CFO and chief marketing officer. CIO, maybe sometimes we have a chief technology officer. And then you're going to have chief operations officer. So operations officers are going to be, in some cases, technical as well. But in reality, I would say, like, the CFO and the CMO, especially for early stage startups in 2020, very, very important. Hard product driven companies rather than software companies might demand a COO a little earlier on, because those people can help with logistics a little better than a CFO or a CMO or a CEO probably can. And so we probably see those a lot more in manufacturing spaces. But I mean, we see them for both sides: software, technology. I mean, hard products, whatever it might be. You usually want to tie these into incentive stock options or non-qualified stock options or restricted stock purchase agreements, where they're giving continuous service for an extended period of time in exchange for vested options or vested equity. And in some cases, like, we ask that these people buy in. And I want to talk about this for a second. I will tell you that of all the customers that we have had that that had founders that never bought in, those founders ended up being problems. Because they don't have the level of commitment that anybody else does. They're not attributing the losses of the company to their own money, and they're not seeing it as their money going down in those bank accounts the same way everybody else is looking at it. And so I mean, in my opinion, if you're going to take on an executive, I would ask that they give you something to make it worth it. And it's not because they have to buy in to get the privilege. It's because some founders, especially if they're first-time founders, they just don't understand what it's like to put your money at stake. You've got to have skin in the game. And so, I mean, I would say for more experienced entrepreneurs and people that have done this before, or people who do C-suite positions like early stage startup CFO positions and CMO positions for a living, maybe not necessarily a capital contribution. Maybe we can recognize it as services because those people have been around the block and actually done this before and have a reputation. But for people who don't have a reputation, for people who have no track record, get their commitment. It motivates them more. I mean, and that's true of all businesses, really. You see people who are more motivated when they put their money at stake. So the typical minimum is 2 to 3 years, and generally, like we always have what's known as basically like a 1-year cliff on any vested equity or stock options. The reason for that is these people need to stick around before they get X amount. Now, sometimes we agree to, okay, we'll give you 25% up front, the other 75% after that 1 year period, and then it'll start vesting in equal increments over the remainder of that contract. And then that contract will come up for renewal when it expires, or something along the lines of 60 to 90 days before it expires. And so at some point they're going to get everything if they stick around long enough. That said, we come back to the forfeiture and the clawback and the recapture provisions. You definitely want those in there because, I mean, if that person leaves and they have a mix of vested equity and unvested equity, you need to make sure that they're not entitled to it upon the exit. Unless, of course, there is a term that says, hey, you fired me, it wasn't agreed upon, I have to be, and they had to be fired for cause, but you fired them without cause. I mean, that constituted an accelerating event, which means that person gets all their equity all at once. I mean, there are terms like that in some of these agreements, and people do, and some CFOs, some CMOs, and C-suite executives who do early stage company growth, they will demand those terms because, I mean, they know that, hey, I can get you to 10 million ARR like in a year. I can get you to 50 million in 3 years if you want. I mean, because they've done it before and they know how to do it, so long as you give them the resources and the tools to. And so if they're going to provide extreme value, consider it. Consider every offer you get when you're negotiating these. These are really heavily negotiated sometimes. Other times they're really not. The requirement to renew or assess raises in compensation each year, I think most people are going to want to at least assess their compensation each year because, especially if the startup is brand new and has yet to earn money, obviously their compensation is going to be fairly low compared to the equity compensation. So we're going to be offsetting the lack of cash that the company has to give that person a salary by giving them more equity to cover their risk. But like as time goes on, you do want to make sure that the company will have enough liquidity, have enough cash to be able to pay that person a reasonable salary so they can live. I mean, just because they're getting 25% of your company doesn't mean they have to live on they have to live on rice and beans for the rest of their lives. People do want to save up money, buy houses, things like that. So here's a question, same style. What is reasonable compensation for bringing on an outside executive? There's no hard and fast to answer, obviously, because these are negotiated deal terms. They're going to go high, you're going to go somewhat lower, but you're not going to want to go super, super low because you don't want it to be unreasonable. You want it to be reasonable enough to where they'll agree to it. And in some cases, I find like a good starting point to be a low median salary in the state of Texas, which would be about 42 grand. In Dallas, 52,000. I looked this up, by the way, this morning. Austin median income 77,000. Austin, considerably more expensive to live in the city of Austin than it is in Dallas, apparently. Well, not apparently, obviously. And so, I mean, at some point, some people may say, I want 80 grand a year. Well, technically, that's actually not a bad ask in some cases, especially if that person's been around for a while or they have a lot of experience in the industry. They have a lot of experience doing what they do for early stage companies. I mean, I've seen $80,000 a year salaries. To give you an idea, when you're raising venture capital, you should keep in mind that the salaries you're paying team members to build the company and get it to where it will grow and earn enough money to be able to organically pay the expenses and salaries of everyone that works for you. Those expenses initially can be taken out of venture capital investment. They don't always have to be invested in products or services. I mean, because you are in a way investing in those things when you invest in the people. So, I mean, salaries can be paid out to yourself and to other people through those venture capital investments. That said, you got to watch how much money is going to you. Your investors are not going to be happy if you're pulling six figures and you got no income coming through the business. They're going to want to see that you're earning a little bit less or just covering your living expenses plus groceries, as well as maybe a little T&E, just to live your life a little bit. But yeah, I mean, we offset the differences in cash with equity compensation, with bonuses, which, by the way, the bonus terms, like, I find it useful to do the bonus terms to where it's other people on the same plane as that person. So a CFO and a CEO and a COO, I mean, those people are probably going to be entitled to the similar or the same bonuses. A lot of times, though, people will want to tie it to performance, whether they reach those goals. Sometimes, I mean, they get those bonuses when they have reached those goals and they get it immediately. Meaning, I mean, you have 14 days to pay that person whenever they've reached your high target for whatever goal you set for the business. And so those are, and these can be really detailed, by the way. The one that I'm writing for a customer right now is very detailed, to the point where, I mean, we're talking 0.5%, like for very specific goals that the company has set. And I mean, it's and the initial starting place is pretty high, but like if they do reach those goals, I mean, the company will make money. And so in some cases, the equity compensation, totally worth it. So another question: what are some ways I can protect myself from a bad executive or one that leaves before their contract is up for renewal? I mean, a bad executive, if you're afraid that person is going to do something wrong, or if you're afraid that that person is going to be sued, or the general nature of the business is that, well, the numbers and dollar figures are always so high, our outstanding contracts are really so valuable that it's inevitable that at one point our directors and officers will be sued, maybe just get directors and officers liability insurance to cover them. That can be expensive, but it's not a big deal if you're earning quite a bit of money in the business. The other thing to protect yourself: strict clawbacks and recapture provisions, like we talked about. Always make sure you have those. You do not enter into a contract that is for equity to somebody over a period of time that you do not have a clawback or a recapture provision or a forfeiture term in there. You have to have that. You have to have it. 30, 60, possibly even 90-day notice requirements prior to top-level executives leaving. That allows you to do a number of things. Number one, most important, allows you to find a replacement. Number two, allows you to assess whether or not that person actually did what they were supposed to in order to get their equity. Allows you to figure out how exactly you can potentially get their equity back, as well as what else you're going to do once that person is left. And then terms providing that no severance will be paid. That's a tough one, especially for executives that have done this before. Usually they are going to demand that they get paid severance if you let them go or push them out of the company, because they need to be compensated for their time. Also, I mean, like in some of the terms are as specific as it's going to be 2.5 times annual salary is what the severance package is going to look like. Can be a lot. I mean, if it were 80 grand, 2.5 times is what 160. It's $200,000. It's a lot of money. I mean, and in some cases, it's set to pay immediately or within like 30 days after that person is pushed out or forced to resign. The other provision is a set of moral turpitude provisions. If that person gets arrested for DUI, if that person gets arrested for some Harvey Weinstein type stuff, I mean, obviously you want to be able to protect yourself from that and burn that person like immediately and fire them and basically say, you're getting nothing out of this company. We're not paying you anything because you did this. I mean, as a matter of fact, like you may say the reason why you're not getting any more compensation is because for the most part, our brand might have been damaged so badly that you need to compensate us for the damage you did. So other than that, looks like we have a couple questions. I believe this is our last slide too, if I'm not mistaken. I'm not exactly familiar with that term. There are a lot of things that we might talk about that might be what you're talking about with slicing pie. It's one of those things where I've yet to hear that term in conversation with somebody. Keep in mind, as a lawyer, the terms that we use are sometimes very, very different than the terms that startup founders and people that are running startups use. If those are colloquial terms and terms that are just out there in the ether, I mean, I usually don't refer to them because I refer to things in very legal terms, especially when I'm talking to people and negotiating against them. Anyways, if you want though, send me an email and describe that to me so I can see if I understand what you might mean by that. What's the other question, by the way? Not necessarily, no. The non-competes in some cases are effective in Texas. So it depends on where you're at, by the way. Non-competes are very, very specific to the state. For instance, I mean, to give you an idea, in Oklahoma, a non-compete and a non-solicitation provision are considered very similar, and for the most part are going to be considered unenforceable unless certain things happened. For instance, if you actually did compete and stole a trade secret, you might actually activate the statute that allows those people to enforce the non-compete that you signed in Oklahoma. For Texas, though, I mean, there are a lot of factors that they assess. They assess whether the region, whether the geographic restriction was reasonable or not. Usually, if you're going any more than 50 miles out from where that person worked or where that person lives, that they're going to have to do what's known as blue penciling, which means they're going to figure out what is reasonable just as a matter of law and as a matter of previous case law. The other thing you have to keep in mind is non-competes are only enforceable up to about 5 years, and really only if you were like a CEO, a CFO, or a COO of a major company. And we're talking like you had to extract enormous value from your job in order to have to agree to a 5-year non-compete. The reason why we don't allow non-competes more than 5 years and why the standard non-compete only lasts for about 2 to 3 years has to do with the fact that we don't want to consume up a huge chunk of people's working lives with non-compete agreements. They have marketable skills that have expiration dates on them. So we want them to put those skills to use. And so a 2 to 3 year non-compete will be enforceable. I would say for a CFO of a major company, a 3-year non-compete, probably good. No big deal there. I mean, most information goes stale after 3 years anyway. So we're not really worried about you competing with us after 3 years or competing with our clients after 3 years. The other factors really are, though, I mean, we're talking about not just time durations, but I mean, did it restrict you too broadly or did it restrict you too narrowly? And so if it was too narrow, you might be able to wiggle out of it. If it was too broad, they might actually consider that to be somewhat unenforceable and very well may just say, we're going to blue pencil that, or we're just going to strike it all together. We're just not going to do that. So it looks like we're coming up on the end of our time. Are there any more questions for the show? If not, I want to thank everybody for coming to Startups in the Law here. We will be doing this again on September 1st, first Tuesday of September. So look out for any emails. Also, look out for a copy of the slides and a copy of the video once it becomes available. Thank you, guys. I really appreciate it. Take care.